Mr. Mushemi?
So, sorry, Your Lordship, I had an issue with my network. I'm saying we joined before.
Did you participate in this application that sought to have the matter taken out of the hands of the 3 judges because they were improperly empaneled by the Deputy Chief Justice?
Yes, that's correct, Your Lordship.
You were in that proceeding? Okay, looks like you can't.
Yes, that's correct, Your Lordship.
All right.
And we have attached even the directions. Our application is very clear.
Very well. Well, the reason why I'm not looking at that application right now. I have the application I have to deal with here. That's why we have to deal with it. That's why I'm not looking at that. I just want clear answers, candid answers from you. So there you are. So who else was a party and was not joined, or has not been named here? Anybody else?
My Lord, there is a party that is not, that was not party grant.
At the moment, please. Dr. Thiakolo, you are saying something?
Yes, my Lord, now that we are dealing with this issue of joinder, I'm pointing
No. We are not dealing with joinder at this point. Let me make it clear. Dr. Thiakolo, what I'm trying to do, it looks to me that the rules are quite clear. Our Rule 79 is clear that all parties and all persons directly affected by an appeal must be named as respondents. And the way to go about it is we first of all establish those who actually were parties before the High Court and who ought to have been named as respondents and are not named. We need to establish who they are first. We can deal with that. And if there are others who want to join at this point, we'll deal with that as a different matter. So
I'll raise the issue of the others then, my Lord, after we are done with the specific concern of the moment.
Yes, indeed. Thank you very much. So, do you have any other who was a party but was not named here as a respondent? I guess, Dr.
Donna?
Yes.
I don't know if I can address the court. My name is Kimoto Teresia Wanjiru Makazi, Tess Kimoto and Company Advocate for the first respondent.
Where were you when we were starting all this business?
My apologies. I was trying to get the link. I had a challenge in getting it.
So that is Tess Kimoto?
Yes. For the first respondent.
We cannot see her. Cannot see her head, small part.
Can you see me now?
Well, not all that we need to see, in the sense that we need to see whether you are properly dressed and so on. We are seeing your forehead.
Yes, I am.
We are seeing your forehead.
My Lord, she's in a vehicle.
In a vehicle?
I think it's a Toyota. Yeah.
And being who you are, you think that's not a vehicle. But Miss Kimoto, if you intend to be in this court, you better be in this court.
Yes.
But not if you are driving somewhere.
Okay.
So sort yourself out. We'll put you on record, but sort yourself out and show some respect for the court.
Okay. Sure. Thank you.
Now,
may I attempt a response on behalf of the petitioners before the High Court, who are the applicants before you? My name is Dudley.
Just a minute, Mr. Dudley. Just. I'm just wondering, subject to what my brothers have to say, it would seem to me that if parties were parties in the court below, and you have not named them as respondents, you really ought to. Because if there was an order of consolidation, of course, this whole business of of cohorts and so on and bundles and so on may bring some confusion. But thing is, it's one thing. And if they participated in the court below, should not be just right that they should be named as respondents in this matter for whatever that's worth, so that unless there is any serious objection, I would think we should have Mr. Mutubwa and Mr. Mahat Sumanes and Mr. Nura's clients that the IBC named as a respondent. We can add them here, perhaps as the 16th respondent. Mr. Kamodo's client can be named as the next respondent, and Honorable Mutuse can be named as the last respondent. That way, we have them there as respondents, and then we move to the business of the day. The business of the day is very simple. The hearing over 52B. Does anyone have any serious objection to that?
Yes, my lord, I have a serious objection. My lord, may I first go on record as
may I place your lordship?
Just a moment.
May I place your lordship?
Just a moment, Dr. Kaminwa. We have just I've asked a question which I see Professor Ojienda attempting to answer.
Yes, my lord, if I may go first, my lord. My lord, I have a serious objection. My lord, we have, my lord, I lead Mr. Mukele for Senate. My lord, I have a serious objection because when consolidation was done at the High Court before the three-judge bench, consolidation touched on several matters, and 3 more matters came after the consolidation, and they also consolidated. We had, my lord, the record will show, over 20 advocates submit on both sides, one side and the other side. But my biggest concern, my lord, is that I do not see, for instance, some of the parties who participated actively in the proceedings in the High Court. I need, my lord, to confirm if there was proper service on all parties. I think that is my concern, that we have parties who are affected by this appeal who are not here. And my lord, it would be really unfair for parties who have not been served to come by orders or by proceedings before this court when there has been no proper service. My lord, the ones who have addressed you are just but few of the parties before the High Court. There are advocates in court who are calling judges guys. I don't see them here. They need to be served. My lord,
well, we are glad they are not here. I mean, you can't have people calling us what you say. Some people are cold.
It's okay, my lord. My lord, my concern is that this record will not be complete if all parties are not served. And I'm sure that even...
All right.
Yes, my lord. That's my concern, that if there's no proof of service for other parties, this matter will not proceed.
All right. Very well.
My lord.
My lord, may I now respond?
My lord, may I go also?
Just a moment, please. Just a moment. We will come to that in a moment. We have established that we have 3 parties here, represented by the advocates I just mentioned.
My lord, on that issue.
Just a moment, please. We have these parties here who apparently you have filed papers, have you? Dr. Mutuba, you filed something, right?
Yes, my lord, we filed an application for joinder, which we now take in the court as disposed of.
No, not yet.
We have not responded to the application.
Not yet. So you have filed something, as
yes.
has Mr. Dr. Kamoto. Have you filed anything in response to the application?
My lord, we had that dilemma. Now that we have not been listed, we didn't have a proper locus through which we would get into the e-filing portal. But as soon as the court clears our participation, then we swiftly proceed to make the necessary filings.
All right. What about you, Mr. Mushemi?
Yes, Your Lordship, on behalf of the intended respondent, we have filed an application. We filed it yesterday and served on all parties.
An application for? To be joined? Or for what?
For joinder.
Okay.
It's an application for joinder.
All right. Very well.
My lord, if I may go, my lord.
My lord.
Yes, Dr. Fiancolo.
Yes, my lord, I think we have a fundamental problem, because even if the answer you have been given is that this application is on the parties cited that participated in the ruling, but that is not that does not take us very far, because assuming this application was to be granted, it would affect all the parties in the High Court. It is not, they are not saying that the proceedings at the High Court be stayed for purposes of the parties who are now before you, but for purposes of all the parties who are before the High Court. So I think we have a problem. The court may need to guide us on how we proceed, because a ruling, especially allowing this application, would affect everyone. And number two, my lord, if you take the ruling being challenged, it also makes very serious allegations against the person of the Deputy Chief Justice. She's accused of playing politics in a judicial role. I don't know whether she should also be cited as a party to these proceedings before we can even take any step.
No, Dr. Tiankolu, Dr. Tiankolu, I don't think we want to go over there. Nobody, she wasn't a party. She wasn't joined in the court below. So the argument relating to all the others who were parties cannot possibly be applying to her as well. Though there's merit, I think, in the issue of if there were other parties, why were they not served?
Lord, allow me to just, my name is Wanyama, with 1 minute, my Lord. My Lord, the dilemma that we are facing in this matter in respect of parties who have been served is that there are two cohorts of petitions which have been consolidated at the High Court. These petitions have been heard together. This interlocutory application, which the subject of this ruling is a ruling which all the parties were heard on this question. So the danger is that if we don't get all the other parties involved, as per the rules of the Court of Appeal Rule 79, then we'll have a problem, because looking at this, it's just half of the parties, actually a quarter of the parties who are before the High Court, who will be significantly affected by this ruling. So our concern is that why is the appellant cherry-picking respondents? What mischief are they pushing?
No, it's okay. Thank you, Mr. Wanyama. Obviously, we would want to put our heads together as judges on this point. But before we do, I want to take this back to Sinamwite, but I had Ochiel Dudley wanting to speak with his permission. And the question will be this: first of all, whether Mr. Dudley, you actually do admit that there are parties who participated in the proceedings in the court below leading to this ruling who have not been served. I need to know whether that is the case. And then,
thank you, my lord.
Just a moment. And then two, as acting president, I did give clear directions, which were that all parties were to be served within a given timeline. So we'd like you, Mr. Dudley, to address us on whether, one, on the strength of the direction given by the court, and more so, really, on the basis of the rules and first principles, all parties were served. Please address us on that.
Thank you, my lord. My lord, if you look at the affidavit filed by my learned friend, Mr. Michael Mushemi, you'll find a consolidation order, my lord. It's annexure EMM1. It is an order made on 24th October 2024. That order is a ticket, my lord, to most of my colleagues, if you'd permit me to call them, Johnny come late. the order made on 2020. 2024.
Mr. Dudley, there's a problem with your...
But the ruling which alleged on 23rd.
Yes.
23rd October 2024. My Lord, this president, very recent president from this court, in the chief stay motion, my Lord, came before this court on the 20th September 2024, barely a month ago. My Lord, Omtata objected to the hearing of the Attorney General's 5-2B because other parties, including Katiba Institute, which I then represented, had not been served. But this court stated, my Lord, that it would deal with the parties before it. That is a precedent this court has always taken, dealt with the parties before it. My Lord, before the High Court, as late as yesterday, a petition from Kitui was sent to the bench. More will be sent to the bench, my Lord. And before the High Court...
Mr. Dudley, thank you. Mr. Dudley, you are making an argument, but yes. I think answer the question I posed very directly first,
yes,
and then make your justifications.
Very well, my Lord. My Lord, so the answer to your question is no. There's no party affected by the ruling who participated in it who has not been joined. The parties listed in the ruling are before the court and were duly served for today's proceedings, my Lord. My Lord might take judicial notice that the proceedings we seek to halt continue this afternoon at 2 p.m. So delay really serves the respondents. We request you, my Lord, to allow us to proceed. The main appeal has been filed and these parties can participate in it. That's all, my Lord. Thank you so much for the chance.
My Lord Presiding Judge, if with your permission, I perhaps may be of some assistance.
Yes.
My Lord, I think the issue is a rather simple and straightforward issue to resolve. The application before you this morning seeks to stay the proceedings as they are now. The proceedings as they are now affect all the parties in the consolidated petition. Now, some of those consolidated or some of those parties are not before you, and they are affected within the meaning of Rule 79 of this court's rules. And because it seeks to stay the proceedings as they are now, I think whether or not the parties were parties on the 23rd, they are affected. The application was only filed on the 24th, the same day as the consolidation. Those parties being affected, I believe they are proper parties to this application. Most obliged.
All right. Thank you. I just have one question. Is it a case of lack of clarity, or is it a case of economy with the truth? When, having posed the question whether these other parties that are here but that are not named, whether they participated in the application that led to the ruling, the answer I got from counsel is that they participated. Was that a truthful position, or was someone trying to mislead this court?
My Lord, let me help the court. My Lord, these proceedings were consolidated with other proceedings.
That's okay.
So that, my Lord, there are parties who participated in these proceedings, in this ruling, my Lord. But, my Lord, these parties are not before the court. So my thought, our concern is that why can't we get the parties, at least the ones who participated in these proceedings, so that we are able to have a complete picture. But more importantly, also, we are making a case that if these proceedings affect parties who are in the consolidated suit, Isn't there a case for them to be heard so that orders cannot be issued in the context where they have not been heard?
Thank you.
My Lord, if you may just permit you 1 second, only 1 second, my Lord.
No, will not permit you. Professor Jenda,
yes,
enough has been said on this rather straightforward matter. Enough has been said. But before my learned brothers and I retire to consider what directions we shall give,
yes,
I'm just inviting my Lord Muchelule. I wonder whether my Lord needs to clarify anything before we retire on this. My Lord Muchelule.
Yeah, thank you, Presiding Judge. Mr. Ochieng Dudley, the application seeks to stay proceedings that are ongoing. Now, are all the parties who will be affected by the decision that we make, one way or the other, are those parties, were they cited by you and served with this application? We need clarity on that.
The straight answer is all the parties in the proceedings as they are now are not before this court. However, my Lord, the ruling was made on 23rd.
That's what I wanted.
Dudley, thank you.
Yes, my Lord.
Thank you. My Lord is saying that he has got...
Please, Your Lordship. Please, Your Lordship.
Just a moment, please. My Lord Dunga.
My Lord, Presiding Judge, I have no question.
Thank you very much.
My Lord, may I say something very small?
Just a moment, please.
Before your Lordship retire.
Just a moment.
What?
Senior Counsel. Just a moment. We're about to retire, but before we do, I'm going to give Dr. Camino a moment, and that means a moment. Mr. Camino, I'm going to give you a minute to let us know what it is you want to place before us, and then I'll give Senior Mwite also a minute. Then we shall retire. We'll come back with directions. Dr. Camino.
My Lord, I represented Kituo cha Sheria and myself before the High Court as an interested parties. All that I want is my name to be on record, that's all.
Thank you very much. Were you served?
I was not served, but it doesn't matter, Your Honor. This is a simple application which I can argue without being served.
No, it's okay. I mean, whether you can argue is another matter. I was just asking whether you were served. Senior Mwite.
I think I was served, my Lord. Would you place me on record as saying that I was served?
You said you were not served, and you even went further to explain, and now you're saying you were served.
Yes, sorry for blowing hot and cold. I was
just
served.
A moment. Are you named?
No, my name is not. It's not on the document, but that doesn't matter.
You are unlike it matters, Dr. Kaminwa. It does matter in this court. It does matter. Senior Mwite.
My Lord, all the parties who are named in the ruling delivered on the 23rd of October are parties and they have been served. I think that is the first important point. Point number two, there is no objection in joining now those who have applied to be enjoined. Last point, my Lord, this is an urgent application of 5